In this video, I would like to talk about the role of LLCs in asset protection when planning for real estate, and if you really need an LLC when you own a rental property. My name is Andrey Milvidskiy, and I'm a managing attorney at Milvidskiy Law Group, where we focus on estate planning and asset protection. You know, one of the most common questions we get from real estate owners, whether they have a single rental condo or a small portfolio, the question is, do I need an LLC for my rental property? And if you've been on YouTube for more than a few minutes, you've probably run into people who say the answer is always yes, absolutely, no questions asked. Some even make it sound like you're practically irresponsible if you don't have an LLC. But the truth, especially here in New Jersey and New York, is, well, it's a little more complicated. And I'd even say it's much less glamorous than the way it's typically presented online. So let me walk you through how I think about this from a legal and practical standpoint, because the answer is not one size fits all. It depends on your risk profile, the property itself, and what you actually need protection from. Let's start with something fundamental. What an LLC actually does. An LLC creates a legal separation between you and the property, or rather the activities associated with the property. If a visitor slips and falls in the driveway, or if a tenant brings a claim because something wasn't maintained properly, the idea is that they can sue the LLC, not you personally. Lawyers call this internal liability, liability that arises from inside the activity of the property itself. The LLC is designed to contain that liability so it doesn't spill over into your personal assets. Now, here's what an LLC does not do. It doesn't protect you from your own negligence in the way many people assume it does. If a landlord personally cuts corners, ignores complaints, or actually participates in whatever went wrong, the LLC won't magically shield that. And the LLC doesn't replace the need for good insurance, a solid landlord policy, proper endorsements, maybe an umbrella on top. I tell clients all the time. Insurance handles the first wave of risk. The LLC is a supplemental layer, not the main fortress. And because of that, there are situations, very common ones actually, where the LLC is not strictly necessary. If you have a modest rental with minimal foot traffic and you already maintain strong insurance and you're not operating some big real estate enterprise, the LLC may not meaningfully change the overall risk. A lot of small landlords in New Jersey and New York go many years successfully without putting their single rental in an LLC because the cost benefit just isn't there. And yes, that runs counter to what many YouTube channels say, but that's the reality in this region. With that said, there are scenarios where an LLC can be genuinely helpful. If you own multiple rentals, for example, or properties with significant equity, or you want to isolate each asset from the others, then having a separate entity for each building, or at least grouping them strategically, can make a lot of sense. But you have to be realistic about how much protection an LLC actually gives in New Jersey or New York. These are not Wyoming. They're not Nevada. Courts here are more open to arguments that a single member LLC is basically the same as the individual who owns it. That's something a lot of online promoters conveniently leave out. And that brings me to something people rarely talk about, piercing the LLC veil. This is the scenario where a plaintiff basically argues that your LLC is not a real business structure, but your personal alter ego. Courts look at how you've treated the LLC. Have you kept separate bank accounts? Do you have an operating agreement? Do you keep any records? Did you commingle funds? Did you treat the property like your own personal piggy bank? And if the answer to any of those questions is yes, the LLC becomes much easier to crack open. In other words, the entity is only as strong as the respect you show for it. And then there's something called reverse piercing. Let's say you personally are sued for something completely unrelated to the property. Maybe it's a car accident. Maybe it's a personal business dispute. Whatever it is, a creditor may argue that your single member LLC is, again, essentially your alter ego, and that the assets in the LLC, meaning the rental property, should be reachable. And in states like New Jersey and New York, that argument is often more successful than people realize, especially where the LLC has only one member and no meaningful separation in practice. A huge part of preventing both piercing and reverse piercing is having a strong, well-written operating agreement. And I know some people may think, Why do I need an operating agreement if I'm the only member? But it does matter. And if something ever does go wrong, having an operating agreement is a major credibility indicator. It shows that the LLC is a real business entity with structure, rules, and internal logic, not just a shell you set up because someone online told you to. Even if it's just you or you and your spouse, the operating agreement matters. Now, let's switch to the topic of jurisdiction, because this is another area where there's a lot of misinformation online. There's a whole wave of people promoting Wyoming LLCs and Nevada LLCs as the ultimate asset protection solution. And listen, Wyoming does have excellent charging order protection, as a few other states. A Wyoming LLC can be a great holding entity in some situations. But here's the part many people don't hear. If your rental property is physically located in New Jersey or New York, the LLC that owns it must be authorized to do business in that state. So if you create a Wyoming LLC to hold the property, that Wyoming LLC must register as a foreign LLC in New Jersey or in New York. And once you do that, the supposedly magical Wyoming privacy and asset protection largely evaporate because now you're playing under New Jersey or New York rules. Charging orders are another area full of misunderstanding. A charging order is basically a remedy where a creditor of an LLC member gets a right to distributions but cannot force a sale of the LLC's underlying assets. Sounds great on paper. But again, the strength of charging order protection varies dramatically by state. Wyoming and Nevada offer strong protection. In New Jersey or New York, the outcome might be different. And single member LLCs in particular are treated far less favorably. Courts may say, look, if you're the only member and you completely control this entity, why would we stop a creditor from getting to its assets? That's why you really need to understand how the structure you are creating would work in your state. That said, there are scenarios where a Wyoming LLC makes sense, but usually at the holding company level, not directly owning property in New Jersey or New York. For example, you can have a Wyoming holding LLC that in turn owns an LLC formed in New Jersey. The property itself sits in the local entity, while the Wyoming entity sits above and adds another layer of privacy and protection, especially for external liability, that is your personal liability. But that's a more advanced structure. And again, it's not necessary for every small landlord. It's really for people with multiple assets where layered protection makes sense. Before you even think about forming an LLC, the most important thing you should do is look at your risk. And this is the part no one online ever talks about because nuance doesn't get clicks. But ask yourself, how much equity is in the property? What kind of tenants do you have? How likely is it that something on the property could cause injury? How well do you maintain it? What does your insurance policy actually cover? And are you personally involved in the management? Once you answer these questions honestly, you might realize that a well-structured insurance plan provides the majority of protection you need, especially for a smaller or lower risk rental. Now, there's another side of liability that has nothing to do with tenants or visitors, and that's external liability, your personal creditors, not the property's creditors. And this is where trust can play a role. Let me be clear. Revocable living trust is not an asset protection tool. It's a probate avoidance and organizational tool. But an irrevocable trust, depending on how it's set up, can offer external protection because the assets in that trust are no longer legally yours. Some people combine LLCs with trust, where the LLC protects from internal liability and the trust protects from external liability. That can be effective in certain cases, but again, not everyone needs it. It's not a standard prescription. And finally, I want to say a word about single member and spousal LLCs in New Jersey and New York. They don't always offer the level of protection people think they do. Courts in our region have historically been more open to the idea that a single member LLC is basically the individual in another form. Spousal LLCs are sometimes treated the same way. So if you're building your entire asset protection strategy around a single member LLC and you think it's as strong as what someone on YouTube described in a different state, that may be an inaccurate assumption. At the end of the day, the real question is not, do I need an LLC? The real question is, what am I actually trying to protect? And what structure realistically accomplishes that under the laws of my state? For some landlords, the LLC is absolutely worth it. For others, it adds cost and complexity without changing much. A lot of this comes down to thoughtful planning, understanding jurisdictional realities, and not taking at face value the more extreme promises you see online. So, if there's one takeaway I want you to leave with, it's this: an LLC is a great tool when it fits the situation, but it's not a magic shield. It's not a universal answer. And in New Jersey and New York, the way it works in real life is often very different from the versions you see promoted by the LLC mills and the gurus. Think about your risk first. Understand your options and build the structure that actually matches your reality, not someone else's business model.